In this presentation, we will discuss the reasons for law, the purpose for law, the objectives of law. At the end of this, we will be able to list components and objectives of the law, describe the U.S. Constitution, describe statutory law in the legal system, and explain common law. One of the main purposes of the law is to have a justice system so that there is some harmony within the social system. The law will help us to create harmony within the social system through having some justice administered through the law and people being able to perceive that both the procedure and the consequences of law are fair and applied universally. If done so, that's typically going to have a harmonizing effect to society. You would think that that would be fairly straightforward at first glance to look at the law and say, well, we want to put laws in there that are going to be fair to everybody, and that are going to be just, and therefore people will be able to adhere to the law and be able to agree with the law. But of course, in practice, that becomes more difficult than we would think at first look. One problem is that we have to put out that law in words, in language, in order for people to be able to understand what is acceptable or not acceptable within a process within the law. And words themselves are not perfect. So many of the problems with law that we talk about in terms of the making of the law as well as the administering of the law and judging whether or not a law has been broken or not, it comes down to problems of language. And that's why, of course, the legal system and lawyers themselves are very good with words, with making things be very definite if they want to, or vague in some cases when they want to achieve different types of objectives when creating the law. But this creates some debates within the legal system, and you're always going to hear these types of debates over, for example, when we're processing the law and looking through the law, should a judge be applying the letter of the law and just make sure that they're applying exactly what the law says, and depending on the wording of the law and or prior precedents that have happened in order to make final decisions? Or does the judge have more leeway to have the idea of the law, the content of the law, or what they believe the spirit of the law will be in order to make judgments on a particular case? This is going to be a type of thing that's going to be very contentious because it really blurs the line between when we talk about the separation of duties between the judicial system and the executive, the creators of the law and the people that are judging the law. That line gets very blurred when we start to lean too much to the type of going toward the spirit of the law, because it becomes very easy for a justice, then the legal department or the legal branch, to then interpret the law in different ways, and possibly in ways that basically would almost be making new laws. I mean, if we can interpret very broadly the language of the laws and how to apply the language of the laws, and even to possibly go against the language of the law in order to uphold the spirit of the law, and then that's going to give a lot more leeway, and it kind of blurs the line between the makers of the law, which is supposed to be a check and a balance, and the interpretation of the law. On the other hand, if we just go by the letter of the law, then we can see that there's going to be a lot of cases when law is created. It's often created in such a way that we don't see all the cases going forward, and we have to write it in such a way that it will encompass as much as possible, and therefore we may not encounter certain types of situations that won't fit directly into the letter of the law as it was intended or written out to be. And those cases will be very difficult to go by the letter of the law sometimes without making some types of interpretation and spirit of the law. So this is going to be a debate that obviously some people are going to be way on one side. We have to have everything in terms of the spirit of the law. Again, very difficult to do, and it blurs the line between the legal and the legislative. And also, it's difficult to know what the spirit of the law is for the creator of the law. If you're talking about a law that was created 100 years ago in a completely different environment, it could be difficult to make that interpretation. On the other hand, the letter of the law, if we go too far on the letter of the law, we could end up making some judgments that don't seem right in the current situation, just in terms of if we think about it just logically, or the types of consequences we would want for a society. And if the law doesn't cover it and we just go by the letter of the law, we may end up with some interpretations or some outcomes that would be not ideal. So probably somewhere in the middle is going to be the correct area to be, and the pendulum swings between this, and we're always trying to find that good middle ground, that good balance to make the best system. And of course, much of that comes in play because of the imperfectness of words. The law has to be expressed. We have to express things in terms of language, and language is an imperfect thing. The words themselves could have different types of meanings to them, and of course, the words aren't going to be able to cover everything that will be involved in the future. We can't see all the things that are going to happen in the future. Therefore, it's very common that when we make the law, when the executive puts the law into place and tries to think through, okay, what's going to happen in certain cases, how should we execute the law in certain cases, that when it actually goes into practice and we're actually having to apply the law, the application of it will typically often be much different than the envisioned application of it at the time of the creation of the law. And that's going to be something that we also often have to work between the branches in order to refine that process down. That's part of the checks and balances. The Constitution, the idea of a Constitution, is going to be a document, one fundamental law for a nation. When we think about the Constitution of the U.S., we can compare and contrast that to some other legal systems where we may just see a common law system, meaning the common law systems being developed from a series of prior decisions that have been made on legal cases throughout history and trying to be consistent with that common law system. A constitutional system will delineate and spell out some of the core concepts for the federal national law, and that'll be implemented or defined in the Constitution. When we think about constitutional law as opposed to just the Constitution itself, the document of the Constitution, and then the constitutional law, of course, will then include some of the other ideas within our normal law system, which is going to include things like the interpretation of the constitutional law, and we end up with the same kind of debates that we have when we talk about these types of balances that we have in terms of the intent of the law and the letter of the law. How do we apply the constitutional law? So we have, of course, the Constitution itself, that document that will define the national law, and then we have the constitutional law study, which will include the interpretation. How are we going to apply the Constitution and the principles within it? When we think about the making of the Constitution and the U.S. Constitution, we have to look back and remember, of course, and many of us go back and we remember the fact that, of course, we were leaving a system of a very centralized system where we had a very centralized body, a king, that is going to be in charge of the legal system ultimately, although we do, of course, have an idea of a common law system as well. And when we left that system, there's very going to be a lot of fear of having a very centralized system. But we do need to note that although a lot of the law that we put together in the constitutional law was applied on thinkers like a John Locke in terms of a natural rights type of system, we also have to recognize that there were a lot of people that in the making of the Constitution, James Madison being one of them, that did want a strong central government, a more strong central government, and there was a recognized need for some central government needs within a strong central government. And that would be thinkers like before John Locke, we had Thomas Hobbes, who was a very strong advocate of a more centralized government in order to keep the peace. He thought basically it was more advantageous to have a strong central government that has the ability to keep the peace. Otherwise, we return to a state of nature, which was thought to be violent, and that was not the state that would be argued. That would be the concept of the social contract theory was basically started with or one of the creators was Thomas Hobbes there, and that would be the idea that we're giving up some of our freedom in order to have a more peaceful life through a more centralized government. That social contract theory was adjusted a lot by Locke. And of course, that's some of that information is going to be represented in our Constitution. And so there's this argument when we first create the Constitution, how much centralized government do we need? We need some, typically in a republic to make it work, But of course, we're going to be somewhat skeptical of too strong of a centralized government. Before the Constitution, we had the Articles of Confederation within the United States, which was there to provide some central authority to hold the United States together. And remember that many of these states at that time thought of themselves as basically state first, nation second. And so there was a need to have some centralization in order to bind together, especially in terms of military defense against invasion, defense against foreign problems. And that's going to be one of the major weaknesses there are in terms of the Articles of Confederation, because one of the things that the Articles were not good at doing was to collect taxes. And the taxes, of course, will be able to fund the centralized government. And one of the major functions of the centralized government is defense. And that's going to be an idea we'll see throughout history as we have more needs for defense in order to defend ourselves, more wars happen. Then those are going to be times when taxes will increase, and often the size of the central government will increase at that point in time because centralization is needed in order to have quick action to mobilize in order to have the defense. Now, you might think that defense would be something that we could do from a state to state level and just kind of pull together. And that was the thought for a while, but the militias that would be state-run militias or private militias have a lot of problems to them because it's difficult to organize them all together in one militia. We don't have it's difficult to fight a war or defend when we don't have a centralized authority in order to run or govern the militia and not have a paid army that's going to be there specifically for defense, to have a professional army in order to, or military, in order for defense itself. And part of this just has to do with the nature of the military in terms of just economic terms, the military being something that is what we call a public good. It's one of those more pure types of public goods in terms of economic terms, and that means it's non-rivalrous and it's non-exclusive. In other words, a free market doesn't really deal well with these types of goods, and the military is one of the most pure examples of a public good. And that would mean that, for example, if the private market was to defend the nation from attack in order to preserve our freedom, then it's not like you can charge individuals for that. If you defend the country from attack, you've defended everybody, whether they pay taxes or whether they pay for the service or not. And therefore, it's very difficult for a market to put together an organized defense system when market forces don't really apply, because you'll have that kind of free rider effect. And that's been recognized very early on, and therefore that's one of the major reasons, one of the major purposes for a centralized government, and that will be in order to have defense so that the states can do what they want to do and have the freedom in order to do so. The major component of the Constitution, one of the major principles within the Constitution, will be the separation of powers into our three branches: the executive branch, the legislative branch, and the judicial branch. And we know that that's going to give us our checks and balances. The concept of checks and balances has come almost a cliche in the US, meaning if we hear the terms checks and balances, we typically almost see that as just meaning a good thing. Checks and balances are a good thing. You can almost say checks and balances are good. And like many cliches, we probably don't really contemplate on that too much anymore, given the fact that it's basically become kind of a cliche. So if we think about it, the checks and balances, of course, are going to be a major component within the system. And remember, within the Republic of the United States, the Constitution is going to set up those checks and balances as a way to restrict the growth of the central government, or one component of the central government, to get too much power. And the idea of that will be that if one component of the central government gets too much power, even if we have a democracy in format to vote in people to office, the centralization may circumvent that at some point in time. If there's too much power in one central area, it could cause a problem in that the people in that area may not want to abide by some type of democratic process at any point in time. And we need to have some kind of checks and balances over the system so that that kind of process does not happen. When considering the three branches, we know that the legislative will be creating the law, the judicial will be overseeing the interpretation of the law, and the executive will be acting out the law. And there's going to be, of course, some overlap within these. We know that when we talk about the judicial branch, we've talked about the fact that the spirit of the law versus the letter of the law is going to have some type of overlap in terms of a check there. Obviously, the judicial branch has the Constitution in order to interpretate the Constitution, and the legislative branch is going to be restricted in terms of the constitutional law, and the operations and the executive are going to be subject to restrictions as well in terms of constitutional law and the judicial, in order to have the checks and balances there as well. The constitutional document can be broken out into two major components, that being the articles, which is the original component of the Constitution, which will lay out the national government, and the organization will be primarily the components of the articles. And then the amendments, which are going to be changes to the original articles. They're going to be additions oftentimes to the original articles. Now, the articles themselves will basically lay out the duties of the three branches of government, the executive, the judicial, and the legislative, discussing what they are and what are going to be their responsibilities for them. The articles also deal with the interstate relations, and this is going to be very important because we want to deal with this on a national level and make sure that we are dealing together in terms of commerce, especially in terms of relations between the states as United States. Remember that we typically at the forming are thinking of ourselves very distinctly as different states, almost states before a nation. And we want to make sure in the Constitution where there's an overlap between states that we have cooperations with the interstate commerce, that we're respecting the rights and the laws and regulations of each state. The Constitution will also provide for the amendment process to the Constitution. And that's going to be a point that we need to make here, because of course the Constitution is going to be a document that is designed to last the time, to go through time and be applicable through time. And there may be, although it is well defined in order to stand the test of time, be times when we need to amend the Constitution, and there needs to be a process set up in order to do so. When considering the Constitution, we often think of the Bill of Rights as being one of the most common factors of the Constitution. This is actually going to be an amendment to the Constitution. When the Constitution is first created, it was thought that it might be adding too much to have basically a Bill of Rights in the Constitution and to leave all of that type of thing to the states. But later on, it was thought that the Bill of Rights will be a crucial part. And the Bill of Rights is really going to follow the concept of a natural law concept, and these are going to be overarching laws that are basically applied to a natural law type of theme. And things like freedom of speech and the press are going to be within the Bill of Rights. Everybody has just a natural kind of, you can think of a natural right in order to express themselves. The right to bear arms, just a natural, again, it's kind of a natural right type of thought. In order to defend yourself, everybody has a right to self-defense, and that's going to be the kind of a concept behind that right to bear arms within the Bill of Rights. Search and seizure with probable cause, so there's got to be probable cause for search and seizure. Again, that's just a concept that you could apply to, that's just kind of a natural right. There's got to be a reason for the search and seizure. The idea of double jeopardy, being convicted of the same crime twice, going after the same person, same crime. Cruel and unusual punishment, another component. And again, these types of things, basically saying the limits of what cannot be done. And note that these things, of course, don't lay out all limits. We can't really define everything that would be involved in what we might think of as natural rights, those rights that would just be part of just being a person. But they are going to list out things that are going to be prohibited, and that, of course, will then prohibit states from making laws that would be not in alignment with these types of laws that are kind of in alignment with the concept of natural rights. Some other amendments to the Constitution, of course, the post-Civil War finally abolished the slavery and had voting rights were going to be guaranteed at that point in time. We had the income tax, which is going to be established in one of the amendments. And of course, that's going to be a major component in order for us to fund the federal government going forward. Women given the right to vote is going to be part of the amendments. So much of what we think about in terms of major components within the Constitution, we probably actually are thinking a lot about the amendments. When we think about the articles, we think about those major branches of the Constitution. When we think about the amendments, we're probably concentrating on our rights, our Bill of Rights, and that being kind of the natural law-based Bill of Rights that was an amendment to the Constitution. The concept of statutory law is going to be the actual written law. So when we think about statutory law, we're thinking of the books, the law codes. On the federal level, we would be thinking of the laws that would be created by Congress and then signed into law by the president. And then, of course, those would be in alignment with what the federal law has jurisdiction over, what they're in alignment with. Each state then would have their own statutory law, and the statutory laws within the state would, of course, have to fit into the alignment of the federal laws of the Constitution. And then each state then within that grouping is going to have their own structure of the law. Now, as we look at these, we're going to say that these laws, we're going to have codes that are going to be able for us to put this law into alignment. We're going to have to basically group these laws together in some way, some logical way. There's going to be a lot of law, and that's going to be the code that we'll use in order to do this process. So the coding is going to have all the statutes of a state or the federal law. And we're going to be wanting to group this information by titles so that we can find relative information as we go through the law code. As we consider the codes of different states, we can see that the states will differ when they make up their law codes. And that could be a problem when we go from state to state. When we go from state to state, especially if there's a problem that is across the state lines, we're going to have a problem in terms of this non-conformity. Now, this may not be a problem in all areas, and we want to make sure that we do have some sovereignty to the states. That's the point of having the sovereign states in order to be sovereign, to make their own laws. But there are going to be instances that we want to make sure that we have some conformity, especially when it's in terms of interstate commerce and trade, is often going to be an area of overlap, of concern, where we want to make sure there is still trade. Because the statutory laws differ, we have a commission basically that was set up in order to look at laws that can be in conformity along and across different states, and that's going to be the National Conference of Commissioners and Union State Laws, the NCCUSL. The goal of the NCCUSL is to look for laws and try to put some consistency for the laws so that they will be more consistent and cause less problems as they're applied from state to state. The Uniform Commercial Code, the UCC, is going to be one of the most significant laws from state to state that is going to try to align the laws when it has to do with commerce. And that, of course, will help commerce across states, help contracts across states, and help dealings across states. And so it's going to be a very applicable law. Obviously, any law that's going to be applied to unify or make the code the same throughout states is going to be a contentious area. But the idea of the Uniform Commercial Code is that there's going to be more facilitation of trade. We want to make the fact that contracts will be easier to make, and that, of course, would be good overall, we would think, for the economy in order to have trade across states. As much of the commerce has gone online now, as we have cyber commerce, then we have the same application of these principles in a different realm in terms of, well, what's going to be these laws of uniform laws when now we're not physically crossing state lines, but there's going to be cyber commerce that can have commerce in one state, for example, and sell things to people in another state. Under what jurisdiction is the law they're going to be? And that gives us another reason, of course, for more uniformity in the types of laws that will be applicable. And the Uniform Computer Information Transaction Act, Uniform Electronic Transaction Act, are some acts that the NCCUSL have been put in place in order to deal with this issue, this new kind of problem in terms of commerce. And of course, as the world gets smaller, as communication increases with the new technology, then the more need there is going to be for some more uniformity if we want to make transactions in commerce as easy as possible. And typically, from an economic standpoint, we typically do. All parties usually, or at least overall, parties usually benefit by having more commerce. Now, of course, there's going to be winners and losers in terms of within particular economies. But if we take a look at the big picture, usually the idea would be that we would have more trade, would be better overall for everybody in general. And that would be the reasoning, the rationale for possibly limiting some of the state right powers, which is a little scary to do. We don't want to take too much power away from the states and centralize it. But at the same time, the argument will be that it might be necessary in order to achieve the goals of better interstate commerce. Then we have the concept of judicial review, and that's going to be the idea of looking at particular legislation and seeing if it is in alignment with the Constitution, if it's constitutionally aligned. And therefore, that's going to be a case where we have this overlap. Once again, we can see where the state may make a law that is non-constitutional. And in order to go through that process, we would have to go through the judicial review in order to make some type of determination as to whether a law that has been created is in alignment with constitutional law, the law of the land. For more accounting information and accounting courses, visit our website at accountinginstruction.info.